It is unprecedented. I mean, the show with Michael Popok and Dina Sayegh Dahl. And Dina, you and I got together with our families for dinner in the same place and not in a Zoom or StreamYard box. And wasn't that a joy
It was
to behold?
fun.
Right? I got to spend time with your husband and you in person. You and your husband. Actually, my second time of having that fortune. I visited you guys both in Los Angeles. You and I met together in New York during the Trump trials. But you got to meet my wife, Natasha, and my baby, Francesca, for a late dinner right before I was heading back to record midweek. That was fun.
Francesca is an angel. She's so adorable on your Instagram. In person, she's her adorableness is so. Natasha was beautiful and so nice. Too bad we don't live in the same town, Popok.
We get together more often. We said that when you guys.
Yeah,
we said that. That's why you got to get a place in Miami.
Okay, let's just do it.
Yeah, and we like LA. We like LA. We like LA. Everybody that's close to us knows we have a very good reason for loving a recent LA trip that we took, where we made a baby.
Right.
So we have. I tell everything to my audience. What do I care? So let's switch gears and move from life to life, and move into the Supreme Court. We have some interesting developments and patterns that we're seeing. Patterns of the Trump administration, right? 10 emergency applications in order to short circuit the way the Supreme Court is really geared up to operate, and how the MAGA right wing and Roberts and Amy Coney Barrett in particular are responding to these emergency applications. We've already got a win-loss record for Donald Trump that we can talk about. And just this week alone, in fact, you and I were going over a list. Some of the stuff happened early in the week and we hadn't covered it. I was like, is that this week? I mean, with Trump, it's dog years. It's just every day seems like a year of our life. I'm getting grayer as we're recording this particular Hot Take podcast. So we got two major rulings about immigration policy and Donald Trump's immigration policy. One related to the Alien Enemies Act, the other one about Mr. Armando Abrego Garcia, which have implications for the rule of law into the future. We've got a request, the 11th now request by the Trump administration for emergency applications so they can keep two people one off the Merit Service Protection Board, the other off the National Labor Relations Board. What they really want to do is just completely decapitate and immobilize those two organizations so they don't function any longer. We'll talk about that. Then a win for the Trump administration in a ruling against Judge Alsop in San Francisco about probationary employees. We'll sort of tie it all together in a neat ribbon right here on Unprecedented that you can only get on Legal AF. How are you, Dina? I mean, since I've seen you for dinner on Wednesday, how you doing?
Pretty good. I know. I need to be on vacation again.
Yeah.
The amount of stuff that Trump throws at us, like you said, just this week alone, it's unbelievable.
Yeah.
It's nonstop for sure.
Nonstop for sure. Why don't you want to pick up with the Alien Enemies Act? Why don't we do Abrego Garcia first? Because so many moving parts there, including back at the Zinnis, the federal judge Zinnis level, including things happening today that we'll be reporting on throughout the weekend. But it started with a Supreme Court decision. And a very interesting, one of the rare times we got 9 justices agreeing on something against Donald Trump. I mean, you can't even get them to agree on their sweet greens order. I don't know how this happened. Why don't you talk about the 3/4 of a page decision, and then we'll move it forward to how it's operating in real time with Judge Zinnis in Maryland.
Well, I think as most people probably know, because it has been widely reported, basically the Supreme Court agreed with the lower court that the administration had to facilitate his return in order for him to receive actual due process, whether or not he should or should not have been deported. Now, the key reason why all 9 justices agreed is because for a judge not to believe in due process is basically saying you are pointless. The whole point of the judge is due process. The 9 justices didn't go into the merits of whether or not he should be deported. They just said he needed due process before the administration deports him. And I think that's why we got a unanimous decision here, because without due process, there is no law, really. And so for any of those judges to have said the administration didn't need due process, it's like they are voting against themselves, I would say. So that's the key for that decision. Obviously, a huge win for people who care about the law, because without due process, I mean, the due process is a cornerstone of our legal system, whether or not it's in a civil setting with lawsuits or criminal setting. That is how we are protected when we go through the system is something like due process. So do you have something there to add there before we...
No, I think what we have is, I mean, even though Sotomayor and Kagan and Jackson would have gone further, all 9 believe that the Judge Zinnes, who we're going to talk a little bit about, was completely right and vindicated. This is a judge who's been attacked mercilessly by MAGA, Trump, and people in his entourage for being leftist and Marxist and activist and all this other corrupt and all this stuff. And you know what she is? She's an affirmed district court judge who just got, who is now, and there's no, now, that's an old line about if you're going to shoot the king, you got to kill the king. Otherwise you have a wounded, pissed off king. Well, they took their shot at Zinnes, didn't work. And now they're back in her courtroom. And the court was quite clear that when it came to her ruling about her protecting the due process and constitutional rights of Abrego Garcia, who was deported and removed over, and the government knowing that he was subject of a protection order, and yet they illegally sent him to El Salvador, not under the Alien Enemies Act that we'll talk about next, under another deportation standard. They know that. And that drove the decision of the Supreme Court and Judge Zinnes, which is, we have, I don't want to call him an innocent man, because I don't know his guilt or innocence at this moment. I'm focused on due process. But we have somebody who was illegally deported and has been rotting in a jail for 29 days. And the Justice Department and the Department of Justice doesn't care about it. And that is annoying the Supreme Court and pissing off Judge Zinnes. So they remanded it back to her with only one instruction. They said, everything you did was right. Everything you ruled is right. Your jurisprudential underpinnings and your analysis, all right, right on. Your ruling that you needed to do this in order to protect the due process rights of this individual, correct. Your language that you used in your order, all right, except for one word we want you to clarify. You were right to order that the Trump administration immediately facilitate the return of Abrego Garcia. You used the word effectuate. And we're not quite sure what you mean by that. And if you mean by effectuate, they don't say this, but this is where you see between the lines. Supreme Court saying effectuate is putting something into action. Facilitate means you're encouraging through your own actions, through everything that's in your power. You're encouraging an outcome or encouraging somebody else to do something in conduct. Effectuate means if all else fails, you're going to do it. And what they don't want is the judge to order effectively SEAL Team 6 to knock down the wall and take them out of that prison to effectuate. So she cleared up the problem. The order came out at 7 p.m. on Thursday night from the Supreme Court. We all reported on it. Within an hour, Judge Zinnes got it. Now, freshly off a win at the Supreme Court. Nothing puts a pep in your step as a federal judge to get a big win at the Supreme Court. And I'll go back one thing. There's one line in there about if you effectuate, we don't know what you mean, be careful, you might step into foreign affairs and the exclusive power of the executive branch. That's the only reference to it. Of course, that's the part that the Trump administration circled and are lying to the American people by telling them, see, we were vindicated. We have foreign affairs powers. That's not what the case is about.
Right.
You have to be intentionally misreading it in order to come to that conclusion so you can capture the news cycle. So Zinnes gets it and says, I'm going to fix everybody's wagon. I hear you, Supreme Court. I hear you on instructions on remand. And I'm going to take my red pencil, my blue pen, and I'm going to take out the word effectuate. And I'm going to double down on the word facilitate. And I'm going to tell you, Trump administration, to facilitate with all necessary steps to get him out. And I'm going to take away the deadline that I originally set, because you guys seem to be concerned about deadlines. And I just want to hear what the Supreme Court says I'm entitled to hear as a officer of the court administering justice. What have you done to get him out? What are you planning to do? Let's have a hearing, and tell me all that to get this ball started tomorrow morning. Monday, this would have been Friday morning at 9:30. Trump administration freaked out. Can't do it. Sorry, Judge. Too soon. We're busy. We're looking over the order. We'll get back to you. Judge said, excuse me? She wrote another order and said, your motion for an extension of time until the 15th or 16th of April, denied. Denied. You have till 11:30. We'll see you at 11, and we'll see you at 1 o'clock at a hearing. 11:30 comes. He did it again. Talk about picking your losing battles. Sorry, Judge. Can't do it. Impracticable. You're setting deadlines we can't meet. And you're not allowed to set deadlines anymore. That's what the Supreme Court said. We're like, where did the Supreme Court say that? The judge can't administer her own courtroom and set her own rules.
Right.
So the hearing got worse. Have you seen the order that came out from the hearing?
No. Tell me what happened.
Oh, so the order came out, and she said, effectively, she said to the lawyers for Abrego Garcia, this is for Saturday, I'm going to encourage you to file another motion. She just told Abrego Garcia's lawyers that she wants them to file a motion for contempt against the Trump administration. In her order, she said you had no excuse for noncompliance. I asked you simple questions, Mr. Ensign, for the Department of Justice. Where is Mr. Abrego Garcia? And what have you done to get him out as of right now? And you had no answer for me. That troubles me, especially given the Supreme Court decision. Well, we don't read the Supreme Court decision that way, Judge. She said, I don't know how you would have read the Supreme Court decision. So in her order, she said, I fixed my order. I solved the problem. You came to my courtroom not only ill-prepared, but you also suggested, listen to this, Dina. You also suggested, Mr. Ensign, that you were not given information by your client, the administration, purposefully, so you would come into my courtroom without knowledge. That's a problem.
It's a problem.
And the fact that he admitted that, I wonder if Drew Ensign is going to survive.
Yeah.
Or if he's going to get fired like his predecessor got fired for it. So she said, here's what we're going to do. Every day, starting Saturday at 5 p.m., you're going to give me a status report every day until I tell you to stop. It's like hit yourself with a stick every day until I tell you to stop. And then you're going to tell me what you've done to get him out and where he is every day at 5 o'clock. And I'm going to see you on Tuesday at another in-court hearing to get this coming Tuesday. And then she looked in the order at the plaintiff's side. Quinn Emanuel, the big law firm that's representing Abrego Garcia, and said, I'll invite other motions by Saturday at 5 o'clock, and Sunday at 5 o'clock, you guys can respond. I mean, that's where we're at right now. The question is here's the question for you. Is the Trump administration going to run back to the Supreme Court and try to get some sort of relief from because they don't like that she's being mean to them? Like, what do you think?
I mean, they might try, but the Supreme Court opinion, clearly when they were trying to tell her to clarify it, and the argument about national security says that the judge can ask for steps for how the administration is planning on having him return. I mean, they say that in the opinion. So she seems well within her authority from the Supreme Court. But that doesn't mean that they're not going to try to go up, but they would fail for sure. A judge asking the party to come in and tell her how they are planning on fulfilling the order is par for the course. That's something that judge does in every case. And clearly the opinion in the Supreme Court allowed her to do that. So yeah.
We'll come back. I mean, there's a lot of action right now, a lot of activity.
I mean, I think the bottom line is that stalling is a big legal strategy that the Trump administration is doing for all these cases. And so stalling in this case, the more that they stall for time, the harder it is going to be to bring him back. And they know that. So I'm glad that the judge, though, is as you said, emboldened by the Supreme Court opinion, and certainly not going to let them get away with this.
He's day 29 she'll be 30 tomorrow, having been kidnapped and sent in prison. He's like the Count of Monte Cristo. I mean, you got to get the guy out, bring him home. And that's what the judge said. To your point, the judge during the hearing with Drew Ensign said, I'll tell you what I'm not going to do. I'm not going to let the administration and the Department of Justice slow walk this or relitigate things that have already been decided by the United States Supreme Court. That we are not doing. Yeah. So listen, right judge for justice, wrong judge for Donald Trump in Judge Zinnes, and we will follow her closely here. Why don't you take the lead, since I did a lot of the analysis on Abrego Garcia? Why don't you take the lead on the Alien Enemies Act and Boasberg, and you can do a little teach out on the habeas, on writ of habeas corpus.
Yeah. So I know some people see this as a win for the Trump administration. I don't know if I see it that way, because as we know, the under the Aliens Enemies Act, what happened was the groups, including the ACLU, brought a lawsuit in DC, right? In part because they probably thought the judges there were going to be friendlier to this lawsuit. And they brought the lawsuit under the Administration Procedures Act, which anyone paying attention has seen this act be brought up time and time again about because most of Trump's orders are violating this act. And so this was they said that basically the way that they deported people under the Aliens Enemies Act also violated this act, the Administration Procedures Act. And that was their way of trying to get the jurisdiction in the DC court. And the Supreme Court didn't agree with that. They said that this really isn't properly brought under this act, that the right claim is a habeas corpus claim. And habeas corpus is really, it's actually in our Constitution. It's a theory of law that's kind of around the world. And it's the idea that the government is imprisoning you unlawfully. That's the general claim, the habeas corpus claim. You are asking for relief, that your imprisonment is unlawful. And those claims are brought in jurisdictions where you are imprisoned. And that was what the Supreme Court relied on. And they said because they were imprisoned in Texas before they were deported, they need to bring these habeas corpus claims in Texas. And because of that, this has to be rebrought now in Texas. And so it seems like a win, and it is a win for Trump. It's a temporary win for Trump, though. And that's the thing about a lot of these court cases that we're talking about with Trump. A lot of these so far are like procedural issues that maybe the Trump administration gets an injunction reversed or, the stay reversed. But the Supreme Court isn't really going to like the substance of the case that often, although I would say the case we just talked about was more substantive in terms of it not just being a procedural issue. But in this case, I think really it was more procedural. It was like, you need to bring this claim in a different jurisdiction. And they made a point of saying that all 9 justices believed that all of the people who were deported, and any future people that are deported, need to have had notification that they could contest being deported. Because if you notice, we talked about this in the last episode, that didn't happen, that they in fact received like these paper notices that told them that they were being deported and under the act, and in fact implied they didn't have any right to contest it. So they said that, people had to be notified, had to be given ample time to contest it. Again, really linking this case to the one we just talked about, with the Supreme Court saying these people are entitled to due process. And all 9 justices do agree with that. But in the meantime, right, that's the problem, is in the meantime, the Trump administration can continue to use this Aliens Enemies Act until we see some lawsuits in Texas and kind of see how that flushes out. And that's really where the liberal justices were dissenting, was they would have made maybe the more substantive opinion now, rather than in the meantime have people be deported, because it takes a while for something to get refiled, relitigated, go back up to the Supreme Court. And in the meantime, you're going to have some harm.
Yeah, that's what we're watching, is the strategy of the Trump administration, right? Using the emergency shadow docket, giving the Supreme Court very little time, meaning the Democrat appointed judges very little time to coalesce their votes. It's really just it's like a snapshot. It's like a blink. You don't have time for reflection. You have bare bones briefing. You have no oral argument. It comes up through one judge or one justice, And the Trump administration is trying to exploit that because they know they've got a solid 4 votes and likely almost 5 votes for anything that they want to do. Mm-hmm. And so they'd rather do that than the normal, what we call writ of certiorari route, which is what we normally are used to, which is where 60 or 70 cases end up every year. Full briefing, full record, oral argument, months of deliberation internally leading to some sort of, and vote switching and lobbying. This eliminates lobbying. Mm-hmm. This locks everybody in to their core partisan views, everybody. And then you hope for a swing with no oral argument to do it. And again, none of the camaraderie and lobbying and caucusing that goes on usually at the Supreme Court level is going on now because they're being presented in this emergency fashion. Now, the Supreme Court's doing it for themselves. They can reject all the emergency applications and say, file your normal writ. But no, the 4 or 5, you only need 4 to take the writ and 5 to win. So they're taking the application. And that's why emboldening the Trump administration. So far, we've had 5. There's 11 total cases. We've had 5 rulings and 6 in the hopper. And of the 5, the Trump administration has won 3, in some way, shape, or form, and they've lost 2. So they're doing okay. It's worth it for them because they know they're going to lose at the federal court level with the federal judges where we're filing our cases. So they're trying to use the Supreme Court as a stopgap. Well, speaking of yet another fake emergency, why don't you talk about Gwen Wilcox and Kathy Harris and what the Trump administration is trying to do using the stampeding method of filing this emergency application?
Yeah, and Justice Jackson in that Aliens Enemies Act case, that was her focus of her dissent was these shadow dockets are a problem because there's no real record.
I like the way she put it. She said, we've made errors as a Supreme Court in the past, but at least there was a record that we could point to. Now we're making errors, but we're doing it with a scant record left behind, like no footprints on the sand. That's a problem. That's a problem.
That was a very pointed, let's say, and so true because they do take limited cases. Like just a side note, real fast. I mean, I know a judge, the local judge, he has like 3,000 cases that he manages, right? I mean, you compare that to, you said 60 or 70, the Supreme Court. They don't take that many cases because they're supposed to do deep dive, in depth, in them. They are the last deciders of our law. They are supposed to be thoughtful about it. So the shadow docket is like a complete, like major carve out to how they are supposed to function and definitely a real problem. So, okay, the Wilcox case. So basically we have talked about this case before, but this is coming to the Supreme Court. We had talked before about how it's going to come to the Supreme Court, but the Trump administration has asked the Supreme Court to look into it. The Supreme Court is looking into it. And that what is at issue is basically, when can a president fire a leader of an independent board, right? And the rule back from the 1930s, I can't remember the exact date of that opinion that came about, Humphrey's executor said that a president cannot fire a head of one of these independent agencies, right? This was FDR at the time, and they were kind of trying to rein him in. Since then, not that long ago, in the 2000s, Chief Justice Roberts wrote the majority opinion making a carve out, right? For they were trying to fire, actually, I think it was, I don't misquote me, maybe it wasn't Trump, but I think it might have been Trump firing the head of the Consumer Federal Protection Board. And Justice Roberts allowed him to do that, creating a carve out saying, well, it's because there was just one member of the head. The president's allowed to do that. But if
that was Trump in his first term. Yeah.
Okay. Yeah. So there you go. And, but a multi-member board, a president can't do that. And Roberts specifically said that in his opinion. Now the Trump administration is firing a member of a multi-member board. So if you really took Chief Justice Roberts' word, not that long ago, we're talking about the first Trump administration, this would be a clear-cut illegal action for Trump to be firing the head or one of the members of these boards. the
Yeah, go ahead. Continue. Sorry.
Yeah. So, but Chief Justice Roberts, so basically the lower court had said that reinstated Wilcox to the board, and Roberts basically undid that order, which means, interestingly, that the Labor Relations Board doesn't have their statutory 3-member requirement to do anything. So during this time, until the Supreme Court actually makes a decision, nothing can be done there. Which is
or at the Merit Service Protection Board. So he's basically immobilized both of them.
Yeah.
And if the Supreme Court on merits gives Donald Trump the ability to do that and overturns Humphrey's executor as the precedent, even though they had a chance to do that in 2020 with that Celia Law case, they didn't do it. But if they do that, Donald Trump's not going to put anybody in. He's just going to let it. He doesn't like the National Labor Relations Board.
He
doesn't like the Merit Service Protection Board. You know who likes them? Federal workers and unions.
Yeah.
Good job, unions, not supporting Kamala Harris. Now you have no National Labor Relations Board protecting you against abusive workplace practices and collective bargaining practices. And federal workers, the same. I mean, I don't know. How do you think that one's going to play out with the way the Supreme Court is constituted?
Yeah, I mean, you would think Chief Justice Roberts, what did we talk about 5 years ago? You just finished saying that a president can't do this. What kind of hoops are you going to try to fit yourself into?
What kind of brand of stupid are you?
It's tough. I mean, it's tough when they reverse any precedent, right? When they're reversing Roe, their arguments were ridiculous. But when you're trying to reverse your own precedent that you wrote the majority opinion for, that's a tough pill to swallow. But I believe in Roberts enough that he may twist himself into a knot, because as we've talked about before, the Federalist Society judges, which are, Roberts and Kavanaugh, et cetera, believe in the executive unitary theory, which is an inflated theory of the president. And if you believe in that, you would say, sure, the president should be able to fire these people. But then again, Trump has shown them over and over he's not so trustworthy with that power. So it'll be interesting.
We had here on Legal AF, we had the pleasure of interviewing Jamie Raskin 2 days ago, Court of Accountability Actions, Alex Aronson and me. And in our discussion with Representative Raskin, we were reminded that when Sandra Day O'Connor was the swing vote appointed by Reagan to the United States Supreme Court, and when that unitary presidential model bullshit was presented to her, she looked around and said, I'm sorry, that is a fringe theory that has never been accepted by the United States Supreme Court. This is in the 80s and 90s. And now in 2025, because they've got the numbers, this what had always been considered to be a fringe aberrational theory about, not that there's only one occupant of the executive branch, we understand that. It's that this unitary theory that he can do whatever he wants within the sphere, even if for an agency or a board that was created in a bipartisan way by Congress. That's our problem. That's why I have to answer a lot of questions for some of our international fans and audience, because they're like, well, why is that? The Congress set it up. Why doesn't it just live independently? Because we have to shove something into one of the three branches. And we don't have a fourth branch or a free agent branch where you just get to float out there. So if it's something that needs to execute on policy, that has to go in the executive branch. Once it's there, what Donald Trump doesn't want, and the Supreme Court has been letting him, he doesn't want to have any oversight or checks and balance. And he doesn't want to respect the fact that thing was created in a bipartisan way, specifically to protect it from political whim. That's why these terms are longer, 5-6 years, so it overlaps presidents. That's why you can't have all one party on there. But once you stick it under the executive branch and you adopt the unitary presidential model, then none of that mattered. It didn't matter what Congress intended. But then where's the checks and balance in that? That's why Sandra Day O'Connor said, I'm sorry, that never was really accepted by the founding fathers or framers. I know where it comes from. There's a guy who writes a lot of law review articles named Steve Calabrese. and it's the Steve Calabrese model, and these guys are the adherents of it. But there's other people that write other things, like Cass Sunstein, that are like, no, that's never been out of the framers would never have allowed a royal king president. Are you effing crazy? So this is the battle that you and I have been following closely. And let's end today with a win for the Trump administration related to a decision by Judge Alsop out in your neck of the woods, or at least in California, who ruled that it was arbitrary and capricious to fire 16,000 first-year employees, what they call probationary employees. But we got a new ruling from the Supreme Court on that, at least temporarily, procedurally. And what happened there?
Yeah. So again, this is procedure. And, just to point out too, I mean, the Supreme Court always wants to decide on a procedural issue if they can, because the idea is to make as little changes in the law as possible. This isn't even necessarily deciding on a procedural issue, because they haven't gotten to the point of full briefing, let's say, right? But for example, the case that went in front of them with the abortion pill last term, the Supreme Court decided that they didn't have standing, the parties didn't have standing, and they didn't have to go into the substance, right, of whether or not that should stand or not. But so here, again, on a procedural issue, they said that the nonprofits and the unions were both suing, saying that the way Trump fired the probationary employees was illegal. And the court said that the nonprofits didn't have standing. So the injunction, basically, they reversed it, which would have allowed him to fire the probationary employees, but that the unions can continue and seek an injunction. So, these poor employees, let's be frank. This is the problem. It's like,
you better find a new job.
Am I fired? Am I not fired? The Supreme Court is saying these people can't protect me, but this group can. Kind of a mess. Like, let's be frank, is, these poor people who many of them may have moved and relocated for this job. They have families and schools.
Pay the rent.
Exactly.
Pay for food. They're consumers.
Yeah. They have no idea what their future is. And unfortunately, the Supreme Court didn't give them clarity on that. They decided though, but first step, there's hope still, because clearly the unions will have standing, and they made that point clear at the Supreme Court. But we'll see where this goes.
Yeah,
a lot of tap dancing with the Supreme Court and the Trump administration. A lot of tap dancing.
So 2 observations as we end Unprecedented. 1, I see you have a new microphone.
Yes.
And continuing, you and I always getting along. Do you notice that the color scheme of your painting in your room sort of is picked up in my Japanese art cuts in the back? Do you see a little similar palette kind of coming straight from California to Miami?
That's awesome. Because you have water too, right, in your paintings?
Yeah, well, they're Japanese woodcut things, awesome. But but this similar color scheme. Yeah, I like goofy stuff like that occasionally. So anyway, we've reached the end of Unprecedented. We're going to have so much to talk about next week with Judge Zinnes and her rulings over the weekend. We know the Trump administration is not going to abide by them. They've already started to attack her left and right. We'll cover that and the pickup on some of these cases as the Trump administration continues to think they found the soft underbelly of the Supreme Court and a guaranteed at least 4 votes to be heard in a fast track way of the shadow docket, and what the court is going to do about it. Are they going to continue to invite this type of intemperate, not deliberative process by which major policy decisions are made, or are they going to do their job? And we'll continue to follow it all. You're here with us on Legal AF. Hit the free subscribe button. Follow. We have a new Legal AF Blue Sky.
Oh yeah.
Yes, at Legal AF. Easy to find.
Yeah.
And we're going to be posting, along with Dina Sayegh-Dahl, all of our other contributors here. So go to the new Legal AF Blue Sky, and of course, subscribe here for Legal AF. Dina, any parting shots, last words?
No, like you said, there's going to be a lot more, and we're here to break it down We get to have some fun as we also face all these dire situations. But the Supreme Court, let's leave it at that, could be a lot worse right now with Trump. They're giving me some hope. They're giving me some hope. And it is a tap dance. We don't know how this dance ends, the grand finale, how the grand finale is going to end. But there's some hope that they are willing to stand up for the rule of law, and that's what we need from them.
And we'll keep holding them accountable here on Legal AF and on Unprecedented. We'll see you next week. Shout out to Legal AFers and Midas Mighty. I'm Michael Popak, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touches Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popak Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popak Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popak Firm today at 1-877-POPAK-AF or by visiting my website at www.thepopakfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popak Firm, fighting for your justice every step of the way.